Our final speaker is Professor Kristina Campbell. She earned her BA cum laude from St. Mary's College, that's Indiana, not Maryland, and her JD from Notre Dame. Did I say that right? Mm-hmm. Not Notre Dame. Okay. She has served as staff attorney with the statewide farm worker program of the Central Virginia Legal Aid, the statewide farm worker program at the Community Legal Services in Phoenix, Arizona, and also with the Mexican American Legal Defense and Educational Fund, MALDEF, in Los Angeles. Prior to joining the UDC faculty, she was a visiting professor at the University of Denver Stern College of Law. She will talk about the Barahona versus Holder case, a Fourth Circuit case covering immigration and human rights law, covering how our Immigration and Human Rights Law Clinic got the case, what the issue was on appeal, and the result, and lessons learned from that experience.
Thanks for the introduction. So other clinics have been talking about their success. I'm going to talk about the one case we've lost.
Stay in front of the camera.
Stand in front of the camera, sorry. I like to walk and talk. So I've been here since 2010. I was hired to resurrect the immigration clinic here at UDC. It had been around in previous incarnations, but it came back in 2010. And so one of our very first cases was the Barahona case. We took it on a referral. The focus of our clinic is deportation defense. It's now called removal. It's been sanitized, but it's still deportation defense. So we work in immigration court primarily trying to find relief for persons that are in deportation proceedings. And we focus on people that have criminal convictions and people that are detained, because when you're in removal proceedings, in certain circumstances, the government can detain you, hold you in jail. Pending the pendency of your proceedings. Some people have bond. By statute, some people are not allowed to have bond. Our client had a bond, but was unable to pay it because he had been victimized by an unscrupulous lawyer who stole all the money that his ex-wife had paid, and so that's a story. But so we got the case, and it seemed to be a pretty straightforward case. Our client had come to the United States in 1984 from El Salvador. He was a refugee, an asylee. He came here and filed for asylum because of the civil war in El Salvador. As I'm sure a lot of you know, there was a kind of rubber stamp denial of people from Central America and Latin America at the time who had been filing for asylum. And in the late 80s, early 90s, there was a settlement reached in a case called ABC versus Thornburg, which allowed people who had filed applications for asylum to have a de novo review of their asylum application had been denied. And so our client, who had filed this application, it's unclear from the file if it was on his own or with the help of a notario or someone who was not a licensed attorney, filed an asylum application, got that reopened, and was trying to have a new adjudication on his asylum case, which was then referred through this new special form of relief called NACARA, the Nicaraguan and Central American Adjustment Relief Act is what I think that stands for. So he got referred to immigration court because of other things. And so this whole time he had been here, by this time it was about 2007, he had been in the U.S., like I said, since 1984. He had had temporary protected status for most of that time, which is it's exactly what it sounds like, temporary protected status, where you can work, but you don't have any real legal status. So he lost that status because he had some misdemeanors. There's certain things that you can, that will knock you out of TPS status. So he had no status. He had some, a bunch of minor things, and we were pretty confident that he was eligible for relief from removal under NACARA. So we took the case. He remained in jail. We took the case in September of 2010. Our trial was 6 months later in March, and so our student attorneys worked on it. We thought the biggest issue was going to be a domestic violence conviction that he had from several years before. And so everything went fine with the direct, and the government attorney represented that she had no issues with the eligibility. She just wanted to ask him some questions about his asylum application. So his asylum application that he had filed in 1984, he put his well-founded fear of persecution in his home country was the fact that the guerrillas, who at the time were the FMLN, which is now the ruling party in El Salvador, had taken over his home, murdered his father, and then by force used his home to cook food, and they used the water supply. And so she asked him some questions about this, and he said, yes, that's what happened. They burned down stuff in our village, they were murdering people, they murdered my father, and they came and said if I didn't let them, in my house, they were going to kill me too. And she said, okay, and so then she moved the judge and said that he was barred from relief because he's a material supporter of terrorism. The statute is so broad that the position of the government was, and remained all the way through to the Fourth Circuit, was that he could have said no. But because he didn't say no under threat of death, that he was a material supporter of terrorism. And so the judge was pretty upset about this argument, but felt that he didn't have the discretion, because the statute is very, very broad, to find in our favor. So he said on the record, I'm gonna make a ruling that he is barred from relief because of this terrorism bar, but I would urge whoever the government has the ability to give a waiver, because there's a statutory waiver for this, to do so. So we appealed at the Board of Immigration Appeals, which is it's an administrative appellate body, and they just rubber stamped our client's removal order. So we took it to the Fourth Circuit. And our arguments were novel. There's been some cases, there's one in the Ninth, and actually there was one after our case was a published decision. But our argument was that material support has to be material, right? It's a novel argument. The two words mean, right? You can't separate them out. The material support must be material, and our client is not material. We also had an argument that the statute implicitly doesn't cover people who acted under duress. So that was not a winning argument. We did get a strong dissent from a judge who agreed with our argument that the statute is overly broad. In an oral argument, the government was throwing all kinds of questions about, like, does the statute just mean what the government says it means? Yes. Crazy hypotheticals, like if a pilot was flying a plane and terrorists put a gun to his head and said, if you don't land the plane here, I'm going to kill everyone on board. He lands the plane, saves everybody's life. Is he a material supporter of terrorism? The government said yes. Crazy stuff. But that's the law. It is the law. And so again, even though the judge who agreed with me, his argument was that an omission is not an act, and if you don't do something, you're not a material supporter of terrorism. But that is the law. So our client is gone. He's back in El Salvador after being here for a very, very long time. It was a very hard case for me personally. I think I've always been an activist and an idealist, and this was kind of the case. I think I always joke about it, kind of crushed my idealism. But at the same time, it renewed my fight, my spirit for this kind of injustice. And I do believe one day somebody else will be vindicated, and that this statute is going to be reined in, I hope. But this idea that victims of terror are terrorists is such an incredible perversion of the law. And the clinic, we haven't taken a case like that since then. I'm kind of shy now about the very hyper alert of the terrorism bars, and I've inadvertently become an expert on them. But we have another case right now that is a novel issue, and so we might just lose another case and end up back in the Fourth Circuit. But thank you so much. And,
Thank you all for coming out. Appreciate it.